Picture this. You land at JFK after visiting your sick mother overseas. You've got your green card in your wallet. You've got a job to get back to, rent to pay, a life you built brick by brick. And then a CBP officer pulls you aside, disappears with your passport, and comes back with one sentence that turns your stomach cold. We need to talk about whether you abandoned your residence. In that moment, your green card stops feeling like a right and starts feeling like a permission slip that can be revoked by a system you don't control. And here's the part nobody tells you until it's too late. The most dangerous immigration changes don't always arrive with a press conference. They arrive quietly, through data-sharing pipelines, policy memos, automated flags, and compliance traps that look administrative, right up until they destroy your case. Now I need you to listen closely, because a claim has been spreading, fast, saying Congress just passed a historic new law that forces green card holders into mandatory biometrics every 5 years, imposes travel notifications for trips over 60 days, expands benefit reporting to USCIS, stretches citizenship interviews to 90 minutes, and triggers automated law enforcement alerts that can spiral into removal. People are panicking. Some are making rushed moves. Some are paying immigration services to file forms that don't even exist. And that's why this matters to you personally. The biggest risk right now isn't only what the government might do next. The biggest risk is you reacting to the wrong information and stepping directly into the dragnet, voluntarily. This is Immigration News Desk. And today I'm not giving you a feel-good update. I'm giving you an exposé, how these new law narratives spread, what parts resemble real enforcement trends, what parts are outright fiction, and what the system is actually doing behind the curtain. Stay with me, because about halfway through this video, I'm going to show you the single most common devastating mistake green card holders make after watching viral immigration news. And it's not the one you think. Then near the end, I'll walk you through the real deadlines and rules that already exist today, the ones that can quietly implode your status, even without any new law at all. Let's start with the uncomfortable truth. As of my last reliable policy verification, there is no confirmed, sweeping, just signed today federal law that universally forces every green card holder into a 5-year biometric refresh cycle and a mandatory pre-trip notification for travel over 60 days. That doesn't mean the government can't collect biometrics. It already does. It doesn't mean agencies can't expand scrutiny. They already have. But when you see a script claiming a brand new law instantly rewired every green card obligation overnight, treat that as a flashing red warning sign. Because misinformation in immigration isn't harmless. It's an accelerant. It pushes you into panic decisions, late filings, unnecessary filings, and sometimes straight into scams that steal your identity and money. And here's the part that should make you angry. The internet rewards urgency, not accuracy. The algorithm doesn't care whether a new law is real. It cares whether you feel fear, whether you click, whether you stay. That means the immigration information ecosystem is structurally biased toward escalation. So when you hear historic decision, everything changes today, you need to slow down and ask one ruthless question. Show me the statute. Show me the Federal Register. Show me the USCIS alert. If they can't, you are being sold adrenaline. But this is where it gets serious. Some pieces of that viral claim are not random. They mirror real trends that have been building for decades, and those trends are the real story. The U.S. immigration system has been shifting from a paper-based adjudication model to a surveillance and compliance model. The old system was slow and bureaucratic. The new system is slow, bureaucratic, and automated. That's the difference. And automated systems don't need to hate you to ruin your life. They only need to flag you. So let's dissect the major claims one by one, and I'm going to tell you what's real, what's plausible, what's exaggerated, and, most importantly, what actions protect you either way. First, biometrics. The claim says, green card renewal stays every 10 years, but now mandatory biometric updates every 5 years even if your card doesn't expire. Here's what you need to know. USCIS already collects biometrics in many contexts. Green card renewals, Form I-90, naturalization, N-400, removal of conditions, I-751, certain waivers, certain humanitarian filings. Biometrics are not some exotic new thing. They're a core mechanism for identity verification and fraud detection. And historically, after 9/11, the U.S. built a massive biometric infrastructure, U.S. Visit, IDENT, now transitioned under DHS biometric programs, data fusion between DHS components. The goal wasn't just security. The goal was persistent identity resolution, matching you across systems, across years, across encounters. Could the government expand biometric refresh expectations administratively? Yes. They can increase biometrics requirements through policy and operational changes. But a universal, every 5 years mandate for all green card holders would be a major operational load and would likely be rolled out with formal notice, updated guidance, and clear instructions. If you're hearing about it only through a viral script and not through USCIS's official channels, treat it as unverified. Now here's the open loop you need to hold in your mind. Even without a 5-year biometric mandate, there is a biometric trap that already exists, and it hits people during travel and during naturalization. In a few minutes, I'm going to explain how old fingerprints, mismatched names, and minor data discrepancies can trigger secondary inspection and delays that look like punishment, even when you did nothing wrong. Next claim. International travel notifications for trips longer than 60 days, filed 2 weeks before departure. Let's talk about what is actually true right now in practical terms. As a lawful permanent resident, you can travel. But your green card is not a travel document in the way a U.S. passport is. It's evidence of status that depends on you maintaining U.S. residence. The legal concept you need to fear is abandonment. Not because you left, but because the government can argue you stopped treating the U.S. as your primary home. The traditional risk thresholds you hear, 6 months, 1 year, are not magic shields. They are practical triggers. Trips over 6 months can raise questions about continuous residence for naturalization. Trips near or over 1 year can create serious re-entry issues unless you have a re-entry permit. And even then, it's not invincible. What matters is the totality. Where you live, where you work, where you pay taxes, where your family is, what you own, what you can prove. So when a script says new law tightens it to 60 days, that specific number may be dubious, but the underlying direction, more scrutiny of travel patterns, is absolutely real. Why? Because travel is one of the easiest signals for an automated compliance system to measure. Every entry, every exit, every stamp, every airline record, every API PNR data feed, these are clean data points. And clean data points are what bureaucratic systems love. You don't have to confess anything. The system can infer your residency behavior from patterns. Here's what you should do regardless of any alleged 60-day rule. Keep a travel log like your status depends on it, because it does. Dates out, dates in, purpose, proof of ties. If you take extended trips, keep documentation showing why and showing your anchor to the U.S., lease or mortgage, pay stubs, employer letters, school enrollment, family records. And if you're routinely outside the U.S. for long stretches, stop assuming it'll be fine. That's the kind of casual assumption that ends with you signing a document at the airport you didn't understand. And this brings me to a critical revelation that too many people learn in the worst possible setting. The port of entry is not just a border checkpoint. It's an interrogation room with consequences. You can be pressured into withdrawing your application for admission or voluntarily abandoning permanent residence. Sometimes it's presented like a convenience. Sometimes it's framed like mercy. But if you sign the wrong thing, you can erase years of lawful presence in one pen stroke. Later in this video, I'm going to tell you the exact phrase you need to say if you're ever put in that situation, because one sentence can stop you from making an irreversible mistake. Now, the benefits reporting claim. The viral script says, certain public benefits will be shared with USCIS, not necessarily prohibited, but visible and considered. Here's the real context. The public charge concept has been a political battlefield for years. Rules and interpretations have shifted across administrations, but even when public charge rules change, The deeper trend has been consistent. Data sharing increases. Agencies talk. Systems integrate. And when systems integrate, your life becomes legible to the state in ways it wasn't before. Does that mean using any benefit automatically destroys you? No. And you need to hear that clearly, because fear can make you avoid programs you are legally entitled to use. Programs that keep your kids fed or keep you medically stable. But it also doesn't mean benefit usage is invisible. Even outside public charge, there are good moral character considerations for naturalization, financial support issues, tax compliance issues, and questions about whether information was disclosed consistently across applications. So the smart move isn't panic. The smart move is documentation and consistency. If you use a benefit you're eligible for, keep records, keep approval notices, keep dates, keep the reason, and make sure your tax filings and addresses are clean and coherent. Because one of the most damaging patterns USCIS sees is not "you needed help." It's your story doesn't match your paperwork. Now let's talk about the claim that naturalization is being hardened. More documentation, longer interviews, deeper checks including social media and financial records. This is where the viral script is most believable because the direction is not fantasy. Naturalization has already become more document-heavy over time. USCIS already cross-checks travel, taxes, marital history, selective service, child support obligations, criminal history, and prior immigration filings. And the modern adjudication culture is increasingly about risk mitigation. If an officer thinks your file has discrepancies, they can slow walk you, issue a request for evidence, or refer issues for deeper review. Will every interview become 90 minutes? Not necessarily. But you should behave like it could, because the hidden danger here is not the length of the interview, it's the fragility of your continuity. People think citizenship is just paperwork, but naturalization is also when USCIS can relitigate your entire immigration history, how you got your green card, whether you misrepresented anything years ago, whether you maintained residence, whether you filed taxes correctly as a resident, whether you registered for selective service if required, whether your trips abroad break continuous residence, whether a dismissed charge still reveals conduct. Naturalization is not only an upgrade, it's a full audit. And here comes another open loop you need to stay for. There is one normal habit, something millions of green card holders do casually, that can quietly sabotage your naturalization file years later. I'm going to explain it after we get through the employment piece, because it's one of those traps that feels harmless until the day it detonates. Employment verification. The script claims employers will have to re-verify green card holders every 5 years, aligned with biometrics. That specific requirement is not something you should accept as automatically true without documentation, because I-9 rules and anti-discrimination rules are very specific. Generally, lawful permanent residents present a green card for I-9, and employers should not over-document or re-verify in ways that violate anti-discrimination provisions. But here's what is absolutely real. Employment verification is becoming a compliance battlefield. E-Verify expansion efforts come and go. State-level mandates exist. Corporate compliance departments are increasingly aggressive, and employers sometimes ask for documents they are not entitled to ask for because they're scared. So what does that mean for you? It means you need to know your rights and your obligations. If your card is expiring, renew it early enough. If you have an I-90 receipt that extends your status evidence, understand how to show that properly. If your employer is demanding extra documents, you may need to push back carefully or get legal help, because over-compliance by an employer can wreck your job even when you're perfectly authorized. Now, the fast-track citizenship for shortage occupations claim. There are real policy debates about retaining talent, healthcare, STEM, research, education. There are proposals, pilot programs, workforce bills. But citizenship timelines are statutory and usually not changed casually. If someone tells you a brand new fast track exists and you can naturalize in 3 years just because your job is in demand, you should verify that against actual law and USCIS policy. Don't rearrange your entire life, don't file prematurely, and do not pay anyone who says they can guarantee you a shortcut. Immigration is asymmetric warfare. You have everything to lose, and scammers have almost nothing to lose. Now let's hit family immigration and the age-out protection claim. There is already a law called the Child Status Protection Act, CSPA, designed to prevent some children from aging out because of government delays. It's complicated, and it doesn't solve everything. The viral claim that a brand new rule freezes a child's age after 2 years of waiting is not something you should accept at face value. But the underlying pain point is painfully real. Families get separated, not because of wrongdoing, but because of bureaucratic time. The system isn't built around human timing. It's built around queue timing. And queue timing doesn't care about birthdays. If you are petitioning for a spouse or unmarried child as a green card holder, you need to understand the visa bulletin, priority dates, and what happens if your status changes, especially if you naturalize. Sometimes naturalization speeds up categories. Sometimes it complicates categories. It depends on the relationship and classification. And here's a subtle but devastating mistake I've seen. People assume any change is good and make moves without mapping the category consequences. Later in the video, I'm going to show you the 3 questions you must answer before you change anything mid-process, because one wrong assumption can add years. Now we get to the part that makes this whole story feel like a threat matrix: criminal conduct and deportability, plus automated notifications. Here's what's true in the larger historical sense. The deportation machine was dramatically intensified by the 1996 immigration laws, especially the expansion of aggravated felony definitions and the tightening of relief. After that, the system increasingly treated certain convictions as near-automatic triggers. Over time, data systems improved. Cooperation between local law enforcement and federal databases expanded. Even when formal programs change names, the underlying capacity remains. The government can learn about arrests and convictions quickly. Does that mean every arrest equals deportation? No. But it does mean this. If you are a green card holder and you have any interaction with law enforcement, you cannot treat it like just criminal court. Because immigration consequences can be wildly disproportionate. A plea bargain that looks minor can be catastrophic in immigration terms. A suspended sentence can still be a sentence. A no-jail outcome can still be a removable offense. And here is the trap. Criminal defense attorneys are trained to minimize criminal penalties. Immigration attorneys are trained to protect status. You need both perspectives, and you need them before you plead, not after. If you remember nothing else, remember this. Never assume a misdemeanor is immigration safe. Never assume a dismissal erases the record. And never assume a quick plea is moving on. For the immigration system, moving on is sometimes exactly how you lock yourself out of relief forever. Now let's talk about the positive-sounding claims in the viral script. Provisional extensions, emergency replacement, streamlined removal of conditions for conditional green cards. Some of these themes reflect real operational pressures. USCIS backlogs have been brutal. Extension notices have been used to bridge gaps. Temporary evidence like an I-551 stamp exists in some circumstances. Emergency appointments exist in limited forms. But again, do not treat viral details. 72 hours, 30 days, dedicated windows nationwide, as guaranteed. USCIS is not a vending machine. Local field office capacity varies. Staffing varies. Priorities shift. If someone sells you a fantasy timeline, you can miss the real one. Now I'm going to deliver the devastating mistake I warned you about, because this is where viewers usually drop off, and it's exactly where you need to stay. The most common catastrophic mistake green card holders make when they hear about new requirements is they start filing things preemptively that create contradictions. They submit unnecessary travel notifications through third-party websites. They pay someone to update biometrics outside a real USCIS notice. They upload documents into the wrong portal. They mail forms that don't apply to them. And in doing that, they generate a paper trail that can later be used against them, not because they had bad intent, but because the story becomes incoherent. In immigration, coherence is currency. Your addresses, your dates, your travel, your employment, your taxes, your marital timeline, they need to line up. When you panic file, you create mismatches. Mismatches trigger requests for evidence. Requests for evidence create delays. Delays create missed trips, missed jobs, missed deadlines. And that spiral is how people lose years of stability. So here's your protection protocol: grounded, real, and effective, whether or not any new law is coming. First, know your actual obligations that already exist. If you move, you generally must update your address with USCIS using the proper process, and you should do it fast. People ignore this and then miss notices. Missing a biometrics appointment or an interview because you didn't get the letter is not a persuasive excuse when the system shows you never updated your address. This is one of the quietest ways people fall out of status or get cases denied, not with drama, but with returned mail. Second, track your travel like an auditor. Not because you love paperwork, because travel is one of the first places continuous residence breaks and abandonment accusations emerge. If you're approaching long trips, especially 6 months or more, get legal advice before you go, not after you return. And if you truly need to be abroad long-term, look into a re-entry permit strategy early. Waiting until the last minute is how people get trapped outside the US with no clean path back. Third, taxes. This is the normal habit that detonates later. I've seen green card holders file taxes as non-resident because someone told them it saves money, or because they didn't understand residency rules, or because they lived abroad for a while and thought it was fine. Then they apply for naturalization. USCIS asks for tax transcripts. And suddenly, there's a credibility crisis. Were you claiming you weren't a resident for tax purposes while claiming you maintained permanent residence for immigration purposes? That contradiction is a gift to any officer who wants to question your continuous residence or your moral character. File correctly. Keep transcripts. Be consistent. If you have a complicated tax history, clean it up with qualified professionals before you naturalize. Fourth, benefits and hardship. Don't self-deny lawful help out of fear, but document everything and understand how it interacts with your broader record. If you're unsure, get advice, because the danger is not always the benefit itself. Sometimes the danger is failing to disclose it properly later, or having inconsistent addresses and household composition across agencies. Fifth, criminal issues. If you're arrested, cited, or even think you might be charged, consult an immigration attorney immediately. And if you already have a record, do not file for naturalization just to see what happens. Naturalization is not a private test. It's a government process that can trigger review of removability in some circumstances. You need to know your risk before you step into that interview. Now remember, I promised you one sentence that can save you at the airport if you're pressured. Here it is, and you need to internalize it. I do not wish to abandon my lawful permanent resident status, and I want to speak to an attorney. You're not being rude. You're preserving your rights. Do not sign anything you don't understand. Do not let exhaustion and fear make you trade away your status for the illusion of convenience. Now let's address the "what should you do today" checklist, but I'm going to give it to you in a way that doesn't depend on viral claims. Look at your green card expiration date. If you need renewal, plan early. Create or secure your USCIS online account through official channels only, because phishing is rampant. Keep digital and physical copies of your key documents: green card front and back, passport biographic page, I-94 history if applicable, prior approval notices, tax transcripts, marriage certificates, divorce decrees, selective service proof if required, and a clean list of every address you lived at since becoming a resident. Start a simple travel spreadsheet. Keep proof of ties to the US. If you're going to be outside for extended periods, plan re-entry strategy like you're planning a business continuity plan, because that's exactly what it is. If you are preparing for naturalization, start gathering your 5-year or 3-year evidence now, not 2 weeks before filing. And when you file, assume the interview will test your coherence: addresses, travel, taxes, relationships, and honesty. Your goal is not to sound perfect. Your goal is to be consistent and truthful, backed by documentation. If you have family petitions pending, learn the categories, learn the visa bulletin mechanics, and be cautious about status changes midstream. If you're considering naturalization while a petition is pending, get case-specific advice because sometimes it helps, sometimes it complicates, and sometimes it does both. Now, I want to circle back to the biggest systemic point, because this is the exposé part people don't want to say out loud. The modern immigration state is moving toward continuous verification, not necessarily through one dramatic law, but through incremental tightening, data sharing, identity resolution, automated flags, and procedural requirements that convert normal life into compliance risk. It's not always ideological. Often it's bureaucratic momentum. Agencies want measurable signals. Legislators want security. Contractors want systems. And you, whether you're a nurse, an engineer, a parent, a student turned professional, become a data subject. That's the reality. So when someone tells you everything changed today, don't just ask if it's true. Ask what the story is trying to make you do. Panic, pay, click, file, leave, because if you can see the incentive behind the message, you can protect yourself from being manipulated by it. Here's what I'll tell you bluntly. Your green card is strongest when your life looks like residence, your paperwork looks like truth, and your timeline looks coherent. That's how you survive regulatory dragnet behavior, by being boring on paper, even if your life is complex in reality. And if you want the real deadline mindset to adopt, it's this. Don't wait for a notice to get organized. The system punishes reconstruction. It rewards readiness. People lose cases not because they were ineligible, but because they couldn't prove eligibility when asked. If this video helped you cut through the noise and understand the actual risk landscape, subscribe so you don't miss what comes next. Because when genuine policy changes land, they often land quietly and then get weaponized by misinformation within hours. That's what we track here, and that's why Immigration News Desk exists, to keep you informed, not inflamed. Drop a comment with the situation you're worried about: travel, renewal, naturalization, family petitions, or a past charge, and I'll tell you what angle matters most so you can ask smarter questions when you speak to a qualified attorney. Share this with one green card holder you care about, because the person most likely to get hurt by viral immigration breaking news is the person who feels alone and rushes in the dark. Stay sharp, stay documented, and stay with Immigration News Desk.